Welcome back, everyone. Our next panel is very exciting. It's the first of our 4 regulatory or law enforcement spotlights, and we are incredibly honored. This spotlight is about the GDPR and incident response, and we're just so honored to have not one but 2 members of the Data Protection Commission, Deputy Commissioner John O'Dwyer and Assistant Commissioner Sandra Skehan, who are both extraordinarily busy these days, so we are particularly grateful to have them here. Welcome, Commissioners O'Dwyer and Commissioner Skehan.
Thank you very much.
Excellent. And Commissioner, by way of background, Commissioner O'Dwyer was appointed Deputy Commissioner of the Irish DPC in August of 2013, and Commissioner Skehan has worked at the Irish DPC since 2013 as well. The Data Protection Commission is the national independent authority responsible for upholding the fundamental right of individuals in the EU to have their personal data protected. And these are the 2 people who are charged with making sure that happens, 2 of the people who are charged. The Irish DPC is the Irish supervisory authority for the GDPR and also has functions and powers related to other important regulatory frameworks, including the Irish e-privacy regulations and the EU directive known as the Law Enforcement Directive. Commissioners O'Dwyer and Skehan are in Ireland right in the middle of it all, and we're going to hear directly from them in a minute. And to moderate this is Rohan Massey of Ropes & Gray, a partner of Ropes & Gray in their Ropes & Gray's data privacy and cybersecurity practice. Rohan focuses his practice on all things cyber, including advising on complex global data protection and security compliance programs. Per Rohan, in a podcast about a week ago, quote, "If we take the European perspective, personal data is any data that has not been irrevocably anonymized." So this is a huge challenge, and I can't wait to hear everyone's perspective here. It's the perfect follow-on to the last panel. Rohan, you're in London. Welcome.
Thanks a lot, John.
Excellent. Why don't you take it from here, and I'll get the next panelists ready.
I will. Thank you. So I'll start by asking a question and focusing it very much on GDPR and incident response. So the GDPR came into effect just over 2 years ago, 2 years, 4 months, almost to the day. It brought with it a mandatory breach notification obligation that was new to the European regime, even though the US has had them since sort of 2003 onwards. And in that time, I've read that there's been at least 160,000, probably now over 200,000 breach notifications across Europe. A staggering figure, in such a short time. So what I really want to try and find out from your perspective as regulator, since GDPR coming in, breach notification, what are the trends? What are you seeing in Ireland? What are you seeing across Europe? Is it working in the way that we want it to? John, can I pass that to you?
Yeah, you can indeed, Rohan. And what I'm going to do is I'm going to make a few opening general remarks, and then that'll allow us plenty of time to have a meaningful interaction and answer particular questions. So I'm going to concentrate on the issue of breaches of personal data in the context of the GDPR, and I think everybody who's listening will know what the GDPR is at this stage. And as you're aware, under the GDPR, there is a requirement to notify data protection authorities of all personal data breaches as defined by Article 412 of the GDPR. And because of this, the Data Protection Commission, us, the DPC, has seen a vast increase in the number of notifications received. Since the GDPR came into being, we've received almost 15,000, of which over 13,500 are GDPR notifications. Others relate to e-privacy and the Law Enforcement Directive and other telco requirements. So to kind of answer your question, the majority of the breaches that have been notified to the DPC, approximately 84% of them, are related to unauthorized disclosure, which frequently occur as a result of human error. So it's kind of the wrong letter in the wrong in the wrong envelope, wrong email address, that kind of thing. It's just pure human error or human carelessness in a lot of cases. So we have, however, experienced an increase in the number of cyber incidents being reported, specifically since the start of the pandemic. This would appear to be related to an increase in the number of people working from home and an increase in the use of IT systems to conduct business during the lockdown. There is a 72-hour time frame in which breaches must be reported, and as as part of the requirement to notify the DPC of a breach, it is also a requirement to do so within 72 hours. This is set down specifically in Article 33 of the GDPR. The DPC takes note of all infringements of this timeframe and are pursuing this issue in a number of ongoing inquiries, along with other matters that are under investigation with those particular companies. So we would foresee that repeated infringements of this requirement will ultimately result in penalties and fines. The majority of late notifications are due to either processed data processors not informing the data controllers in time, or a business unit within the entity not notifying the data protection officer within the adequate time frame. Another issue that has arisen is in relation to technical reports carried out by companies when a breach occurs, and queries have arisen in relation to the powers of the DPC to request sight of the forensic reports that have been produced by a data controller in relation to a breach. Article 31 of the GDPR states that a controller or a processor shall cooperate on request with the supervisory authority in the performance of its functions. So there is a mandatory requirement there to cooperate with us. The DPC, however, has further powers as set out in Section 130 of the Data Protection Acts in Ireland that can be used to inspect and make copies of documents relevant to an investigation. And this would include such documents as the forensic reports. So we believe that those should be made available to us in the first instance. If not, we'll use our powers to get them. Other matters of concern to the DPC, we have identified a number of cases where the same data controller has experienced the same category of data breach on a number of occasions. These breaches have continued over an extended period and demonstrate that the data controller has inadequate technical and organizational measures in place. These types of incidents can occur where an organization has reported a cybersecurity incident and the appropriate technical organization measures were not taken within a reasonable time frame to stop further similar breaches are happening, or not taken at all. Sometimes we find that the company had promised to take action, but in actual fact didn't take it, and then the exact same breach happened again. The DPC is conducting an analysis of these breaches with a view to taking further actions in the near future. And just a few reminder of important issues to assist data controllers and data protection officers regarding breaches. So some of the rules of thumb are: report on time, clearly describe the incident, the steps already taken and the steps you plan to take, have a breach playbook and train staff, retain logs and breach records, and be in a position to demonstrate compliance. So that's just an overview of some of the elements that we're seeing since the GDPR came into being, and we're happy to discuss any elements of that. So I want to leave plenty of time.
Brilliant, thank you. That's quite a broad array of issues coming up there. And obviously, as a private practitioner, I was a counsel clients in that first 72 hours when we're usually in crisis management mode with lots of information going around an organisation, undertaking the assessment of whether to report, what information needs to be reported, and pulling that together. But when we've sort of done that and organisations have got the breach, they're making their notification, what happens after that? How is it assessed at your end once you get it? Sandra, that could be one for you.
Yeah, I'll take this. On a daily basis, this is what one of my units is involved with. So I suppose just a step-by-step through analysis of it. One of the initial assessments that we would do would verify whether or not the notification is in relation to solely data subjects that are in Ireland, or if they have a cross-border effect to them. If there is a cross-border nature to them, there are certain criteria that we have to meet in terms of notifying other DPAs within Europe, and the assessment of what we're going to do on the basis of the notification. We take a qualitative approach overall in relation to these notifications, and we test the information that's provided to us against a number of criteria. I suppose initially that would involve looking at the type of risks that are involved with the data that's at risk here, and the data that potentially has been disclosed or exposed. For example, like if there's a combination of an email address and a password and potentially credit card details in the background, obviously that poses a much higher risk to the data subjects. We also look at if there's special category data involved, these type of things would increase the risk to the affected individuals. So we need to see that action has been taken straight away by the controller to mitigate against those risks. We also look at the risk rating that the data controller themselves have applied to this and the criteria that they have applied surrounding that. Another issue would be the number of data subjects affected by it and where those data subjects reside. If there's high sensitive information revealed in those, we both internally from a communication to the external world is needed a lot of the time. The minute that these things become public knowledge, we've got a vast amount of media attention with it. So we need to be prepared from that aspect as well. So the more information that we get from the organisations at that stage is more than welcome. I suppose the nature of the breach then is looked into human error, if it's due to a lack of technical measures in place. If that is the case, we'd focus on Article 32 then in that instance. Another big, I suppose, criteria that we would assess it and see how we react to it would be whether or not the breach is ongoing or whether the data is retrieved. If that breach is ongoing, we'd try and issue recommendations straight away to the organisations to try and mitigate against those risks. Overall, with every single breach that comes in, and I'm sure there's a lot of people that have dealt with our office previously, they'll know that regardless of whether the risk is low or high, we'll establish the full facts. We go back to the controllers to ask further questions if we don't have enough information provided to us initially. We'll look around the security posture of the data controller in that organisation at the time. We usually ask for the policies that are in place, the technical and organisational measures in line with Article 32 requirements. And look, I suppose generally over the accountability levels that the organisation has in terms of, like, there is requirements within the GDPR under Article 24 that data controllers have to be able to demonstrate to us that they are complying with the regulation. So we'll ask questions around those, but mostly the way we have the notifications assessed and the way we have them worded, it's quite clear to organisations the criteria that we're looking for in terms of our assessment of it.
I mean, it's interesting. So I sort of read in there, I think it was the ICO's annual report for last year, that out of all the breaches they get, and like 95% haven't required any further action. Ours would
be along the same statistics as that as well. I think the vast amount of, I think it's 11,000, in around 11,000 of those notifications that we've got since the implementation of GDPR have been low risk. So most of the time what we will do from that aspect is we'll take a look at what measures they've had in place. We'll try and issue recommendations to the firm to try and bolster their technical measures and the security around those systems. We do, though, however, take an analysis of if there's potentially a huge amount of low risk breaches being notified to us. If we've issued recommendations in the past before, we'll look to take further actions against the controller, be it in the form of an inquiry or use of other such powers in relation to that. In terms of the high risk ones, there isn't an awful lot of them. And I have to say, in fairness to the majority of organisations, they react very quickly to these type of breaches and try and implement measures straight away to mitigate against the risks to the affected individuals.
Okay, I mean, that makes a lot of sense. I know it's obviously a fear that organisations often have. This idea of if they notify, if they over notify what it is. So it's great to hear your perspective on that. Something else you mentioned that I thought was interesting. You said, of course, you know, when breaches do go public, there's a lot of media interest, etc. And in some of the bigger cases, obviously, there's going to be a lot of individuals involved. Are you seeing an increase in complaints from individuals rather than just organisations with regards to security breaches that affect them or that they've read about that they think affect them?
Yes, I actually also oversee the breach complaint handling unit. So In terms of the way we try to manage those is when the organisation is notifying data subjects, we try and persuade them and encourage them to give as much information as they possibly can around the breach, and to put measures in place to be able to, I suppose, ease the affected individuals' minds as to measures that they can take themselves in relation to mitigate against the likes of identity theft or fraud, measures like that. We haven't seen a substantial increase in the amount due to the, I suppose, media attention around them. Because of the media attention, the information is out there. So we find that an awful lot of the complaints that we handle are on the basis that the individual hasn't been provided with enough information around the breach and they're worried about what the risks are to them.
Rohan, can I come in here just a second as well? Just to, there is an extra provision now since the GDPR came into place in the Irish legislation, where people whose data has been breached can make a claim in courts for a non-material damage. So that's a new element, that they can go to court now and claim damages, where that element wasn't really there before. They had to really be able to show material damage, that the breach affected them. It's non-material now, so it's much easier to bring a case. Now, we haven't seen that many of those cases coming through the courts yet. We think a lot of things have been settled outside of court. We're not involved in that process, but it's another angle and another burden and cost to companies who suffer breaches.
Yeah, I'm aware in the UK, obviously, there are a number of sort of group actions now that are either in process or certainly being moved to starting, both on breaches and in relation to, I think, some of the enforcement actions that have been given as people have seen those have publicity as well. So the idea of class actions, we look at, especially across the Atlantic, to what I think is a far more developed or evolved system over there, and the risks that we have over here, it's going to be a very interesting challenge. And so, again, that just spurs me on to another question, I think, which is, in the US, when working with the regulator, I often have the feeling that I get from a lot of clients is that it's very much us and them. Now, they see the regulators quite adversarial. And my perception in Europe is it's slightly more aligned. The regulators are very much sort of supportive to the extent they can be with individuals, especially with organisations, when we're looking into things like breach response. But there may become a point in any investigation where there's a sort of divergence of ideas, whether it's, as you mentioned earlier, the sharing of forensic reports and how, when that should be done, or in an assessment of notifications to individuals. Obviously organisations sometimes push back on doing that because they think from reputational damage, and a regulator's perspective may be slightly different, looking purely at the sort of data protection issue. Yeah, how do you deal with those sort of issues in that sort of divergence when undergoing one of these issues?
I'll also take this one because it has occurred in the past, I suppose. From the breach assessment unit's perspective, what we would do would we request information from the organisation around how the criteria that they've applied to the risk and how they have come up with their own risk rating. We'll assess that and we'll take into consideration any mitigation measures that they may have introduced. If we consider that a proportionate risk still exists, we'll go back to the organisation, we'll provide them with the reasons why we believe that a notification or a communication to the data subjects is still warranted under that Article 34 requirement. We'll ask them to take a further assessment of that risk, specifically looking at recitals 75, 76 and 85 in those circumstances. Most organisations tend to look at risks in relation to identity theft, fraud, financial loss. They often forget about the individual themselves and the risk around potential discrimination or damage to reputation by the data that's after getting out. That's especially in consideration where there's special category, such as criminal records or medical health data. So we do try and get in those kind of circumstances, the organisation to look at it from the perspective of the data subject as well. Often the cases are where we get a complaint that might be in relation to a notified breach. The data subject's perspective of what the risk to them is very, very different to what the controller obviously has determined it to be. So we do try and get them to take into consideration those aspects. I think if after that reassessment by the data controller still exists, we'll have an internal discussion about it. And we'd continue to use the powers of inquiry or any other powers involved that we need to. There is a mechanism also in the context of individual complaint handling within the Irish Data Protection Acts, where we have the ability to actually issue an enforcement notice, which would oblige the controller to notify the data subject of the breach occurring. So there's two aspects to it from a DPA's perspective in that account, as in we don't just take account of the organisational risks, but the actual risks that could potentially present themselves to the affected individuals.
Does time play any role in it? The reason, the thought behind that is, the immediacy of a breach and the impact of it, plus the delay in going through any investigation or taking the steps that you have to take. Does that have an impact on the sort of value of the notification to the individual? If they find out 6 months, 8 months, a year later that this has happened, a long time previously?
Well, I suppose in the context of the legislation itself, it does state that, and it does put an obligation on the controller to notify the individuals without undue delay. I suppose it has to be taken in the context of what the breach is and the mitigating measures that need to be put in place. There is circumstances where it might take a number of weeks for the mitigation factors to be put in place, or for the controller to find out exactly what the breach is. But the higher the risk to the individuals, the quicker that we would request the organisation to notify the individuals, so especially in context of, say, financial matters or something like that, where there is a risk of huge losses to the affected individuals. It'll be taken on, all of this is taken on a case-by-case basis, and is very dependent on the actual breach itself.
Okay, thank you, it's helpful. I know we're running sort of short on time. One other question I'd like to get out, and it's sort of been raised by one of the questions from the audience as well, which is we've focused so far on controller breaches. We didn't, John, you mentioned actually, processor breaches and the delay in the 72-hour response because you haven't heard from a processor. But what about the processor breach themselves? I mean, is this becoming a more a bigger issue and a more complex one for you?
Yes, indeed. What we find now is that because more and more controllers are using processors, and there is a transatlantic processing of data as well, that, what we find is that sometimes when we're notified about a breach and we look at what the contract between the processor and the controller says, it doesn't cover off a lot of the things that it should cover off in relation to the security and the organizational methods of the processor. As well as that, in relation to a controller processor agreement, we do want the controller to be continually supervising the work of the processor to ensure that the proper controls are in place.
I'll just step in there as well, I suppose, from a practical aspect and from what we're witnessing on the ground. We're finding that processors are delaying in the notification to the data controllers, which is they're not meeting the 72-hour requirements at that stage. So we would emphasise to organisations to make sure that they have those contracts in place, which puts an obligation on the processor to immediately notify the controllers that a breach has occurred. We're also noticing that where a processor has had a breach, they've multiple controllers, they notify the controllers, but we may only be notified by a handful of those controllers of the breach. We often interact directly with the processor in these type of cases, and it has been the case where we've obtained a list of controllers from that processor, and we'll chase up with the controller as to why they haven't notified us of the breach. I suppose another aspect which we're seeing in the past number of months is where a processor has engaged with another sub-processor, and that chain of control, ensuring that there's adequate security and technical measures, has been diminished, and there isn't the proper controls from the controller's perspective, and very little accountability exists in relation to those ones. So that is something that we are looking into more.
Fantastic. Truly challenging times. I know we've run out of time. We could have talked all afternoon, I think, on this subject. So I'd like to thank you very much. The perspective has been very, very insightful, and hopefully, I think, of practical use to most data controllers and organisations out there. So thank you very much for your time, Commissioner O'Dwyer, Commissioner Skehan.
Thank you.
Thank you very much.
Thank you, Rohan. Fantastic job. And we're really grateful and honored to be joined by John O'Dwyer and Sandra Skehan of the Irish DPC. Just a terrific explanation of all these issues. We really, really appreciate it. Please come back in 10 minutes. Our next panel is on ransomware, business email compromise, and other emerging cyber crimes. We'll be back at 1:45 British Standard Time. See you then. Thank you.
Thank you very much.